Your good old slip and falls. I grew up in an attorney home. I heard about slip and falls. We've all heard about slip and falls. You know, walking in the grocery store, somebody spills some water. Woo! Let's put something to bed. Slip and falls today, 2017, are not the same as slip and falls as a kid, 1985, 1990, whenever. For premises liability, for a store to be considered liable, they have to have previous notice that a defect existed and they didn't do anything about it. That is the crucial part of a slip and fall that gets overlooked. Sure, Walmart might have some water on the floor that somebody walks up to, slips and says, oh yeah, payday. Okay, well, no, not necessarily, because one, you can't just prove the water was there and you slipped and fell. That's easy because it'll be there, and hopefully you watched one of my other videos and you know to take pictures and document everything. But you need to prove they knew the water was there and they failed to do anything about it. Once you do that, hey, now they might be liable for your injuries. If you're in my office and you're sitting in a chair right here and that chair just collapses and you wipe out, I'm not liable. Now, if I knew that chair was broken, somebody told me it was broken, and I said, oh, I'll get to it, and I didn't. And somebody comes in, they sit in that chair, they fall down, I could be in trouble. That is the crucial part of a slip and fall. But a slip and fall, like every other case in Louisiana, you need liability, causation, and damages. You can slip and fall, and the store knew about it and didn't do anything about it. Liability, they're liable. Well, when you fell, you twisted your knee when you landed, and you went to the doctor who said you have a torn ACL or something in your knee. Okay, you have damages. Did that fall cause the damages? That's liability, causation, damages. That's the three. You got the three, that's your trifecta. You have a case. How bad are your injuries? That's a major factor. Were there pre-existing conditions? Did this slip cause the knee injury, or did this slip just aggravate your prior knee injury? There's a lot of questions that come into these factors. Louisiana says you take your plaintiff as you get them. It's almost, what is it, the egg theory, that if your bones are as fragile as an egg and you get into an accident and your bones break, it's the accident that caused your bones to break. It's not their fault that you were susceptible to having bones breaking easy, but it is what it is. So a big misconception with a lot of people is that they can walk into a place, wipe out on the floor and cash in and get some money. It's not that easy. There's several rules in place about prior notice, but you also have the fact that insurance and even these cases are out there to make you whole, not to make you profit. So when you see or hear people getting these big checks for this slip and fall, I wouldn't envy them. Chances are they're getting, if they did get those big checks, it's probably because they were seriously injured, and you would not want to trade places with them because that's how much it costs to make them whole, not make them profit. So bear in mind, slip and falls are not this giant windfall that you can walk in and scam and make money. Most stores, most places have videos now. Almost all commercial entities I've been to have videos or cameras somewhere. So most things will be recorded. And even if it recorded water on the ground that you walked and slipped in, unless you can prove that they knew the water was there, you don't have a case. And there's not an insurance company out here who doesn't know about that defense, and it's gonna be raised every time. That's where we come in. That's where you can call a lawyer. Sometimes there's ways, you might ask, how do I find out if they had prior notice? There's ways. If it's a state or if it's a parish government, there should be records. There should be maintenance records. Certain stores and places like Walmart and stuff like that, I don't know if you've noticed in the bathrooms or things, there's almost a schedule where they're supposed to go in and routinely check it. Those are ways to maintain whether or not someone would have noticed the defect, and could that defect have caused, is it foreseeable that the defect could have caused someone to get injured? Of course, water on the floor, someone would assume you could slip in. So there's a lot more to slip and falls than meets the eye. It's not like it used to be when I was a kid. I remember hearing the stories about slip and falls daily, and might end up being a reason why we have some problems today in the future. But They're not what they used to be. There's a lot more to it. However, if you have been subject to a slip and fall, or some type of premises liability, a box falling in a store, a chair collapsing, something, hurt on someone else's property, I do recommend call an attorney, call me. We can look into it. Worst I could tell you is no, I don't think you have a claim, and you're welcome to go get other opinions.